क्या ना उनके साथ रजनी?
Yeah.
Yes, sir.
Have you shared the screen? Dr. Sinha will make a presentation, or you will take care of the slides?
No, sir.
Sinha,
Sir will take care of the slides and other things.
Okay, Prashant. Okay. Right. I think let's start. First of all, very good morning to all of you. At your respective places, I expect good quality of environment around, except Delhi. So, welcome to this webinar online on socioeconomic or social impact assessment as applied to land acquisition and also in EIA for R&R. Dr. Sinha is an authority in these things, and he is part of RIA. So he is going to make this presentation today. I'm sure all of you will get immensely benefited by his experience. Please do ask as many questions as you can to Dr. Sinha, because this is a good opportunity for you to really get the inputs from a very eminent person like Dr. Harshit Sinha, who is working not only for Indian industry, but for ADB and also for World Bank projects. Over to you, Dr. Sinha.
Yes. Can you see my screen?
Not yet. Not yet.
Yes, sir, it's visible.
Can you see the presentation?
नहीं, वो नजर नहीं आ रहा है सर अभी.
Not yet, sir.
क्या हो गया?
वो है. Now can you see the presentation?
No. Not yet, doctor.
Wait a minute. Yesterday we tried, it went very well.
Sir, you are sharing your Windows, so you should share the application. In the share menu, you should share application and then the presentation.
Okay, just a minute. Just a minute.
Dept has left.
Can you see now entire screen?
No, sir. क्या हो गया डॉक्टर?
पता नहीं, कल तो चला था, कल we have tested. That time it was.
Share option. Can you guide?
Now can you see?
अभी आया. Full screen कर सकते हैं इसको.
Okay.
Now make it full.
Presentation mode में डालिएगा.
Presentation mode में डाल दिया सर.
नहीं, अभी नहीं आया presentation mode में.
नहीं, मेरे यहाँ तो चालू हो गया.
बाकी साइड वाला भी दिख रहा है.
अब दिख रहा है. मैं तो हटा दिया.
अरे क्या हो गया भाई?
Are you able to see the entire presentation on the screen?
No.
Sir, please put in slideshow, sir.
It is right now in the edit mode. Please put it in the presentation mode.
Yeah, see, I'm doing. Yeah, from here I'm clicking. In my screen it is showing.
Sir, instead of this presentation mode, you should select the button in the of that presentation mode. It will be in full screen mode.
ये नीचे नहीं है.
ऊपर जो है.
एक मिनट रुकिएगा सर।
एक काम कर सकते हैं क्या प्रशांत?
Yes,
प्रशांत
sir. Yes, sir.
बोलिए।
तो अपने तरफ से करके देखना पड़े.
कर रहा हूँ सर, एक मिनट.
You do
नहीं,
it
होना-
and then follow the instructions of Dr. Sinha.
You share my screen, and yesterday it done very well.
Prashant, somebody is
Entire
giving
window,
you back.
entire screen.
Sir, it is visible.
Presentation
Not
is
yet.
visible.
No.
No.
Another window has turned up. Please move the window. Visible?
एप्लीकेशन शेयर कर रहे हैं, पूरी स्क्रीन शेयर कर रहे हैं।
Screen तो कर.
हाँ फोन में विजिबल और इसको प्रेजेंटेशन मोड में
No, there is some guideline from Siddharth
No,
how to
it
do
seems
it.
to be.
My
Sir,
side
I
it
am
is
screen. Is it visible?
It is visible not in full screen, Prashant.
from my side it is in.
क्या कमाल है इतने दिन के बाद भी हम लोग.
कर दो मीटिंग नहीं है, ट्रेनिंग चल
Can you share the screen from my second connection?
అందరికి మనసు మేళమైపోయింది. అవునా
Hello, can you hear me?
Yes, sir. Yes, sir.
क्या हो रहा है?
ऑफ करिए। हाँ,
Sir, is my screen visible?
फुल स्क्रीन नहीं आ रहा है।
क्या visible है स्क्रीन?
नहीं, फुल स्क्रीन करने का था।
क्या चीज फुल स्क्रीन करना? आपका कहाँ से
प्रेजेंटेशन
join
मैं नहीं
किया?
कर रहा हूँ ना, somebody else is doing it.
हेलो,
Yes, sir.
ये मेरा सेकंड कनेक्शन से जरा स्क्रीन शेयर करना, मैं दूसरे कंप्यूटर से करके देखूं। नहीं, यहाँ नहीं है। अच्छा, तो नहीं, दैट्स ओके, बट यहाँ स्क्रीन शेयरिंग का कुछ ऑप्शन नहीं आ रहा है ना। हाँ, मैंने नीचे आप लोग वहां से क्लियर करेंगे तो मैं स्क्रीन शेयर करूंगा ना। स्क्रीन शेयरिंग नहीं, मेरे दूसरे कनेक्शन पे कर दीजिए। दूसरे कनेक्शन में मुझे प्रेजेंट, लेकिन यहाँ स्क्रीन शेयर नहीं हो रहा। टेक शेयर होता है, स्क्रीन शेयरिंग का परमिशन दीजिए। नहीं, आप दूसरे वाले कनेक्शन में ये पहले वाले में। हाँ, दूसरे से करिए ना, तो मैं उसमें तो हो नहीं रहा है। विंडोज में मैक लगा है अभी। यहाँ शेयर ही नहीं कर रहा है। एक मिनट, क्या प्रॉब्लम है सर? Is it coming now? यहाँ से स्क्रीन शेयरिंग हो नहीं रहा है। मैटर है कि यहाँ पर है, यहाँ भी नहीं आ रहा है स्क्रीन शेयरिंग। स्क्रीन शेयरिंग आप ऐसा करिए, पहले नहीं कर दीजिए, मैक में नहीं आ रहा है, पहले नहीं कर दीजिए। नहीं, ये जस्ट सबसे पहले वाले में करना ना। फोन नहीं, पहले वाले में एक स्क्रीन में कौन सा है, तो उसमें स्क्रीन शेयरिंग का दीजिए ना ऑप्शन, टू शेयर द आस्क ऑर्गेनाइजर टू मेक द स्क्रीन प्रेजेंटेशन। हाँ, डॉक्टर हर्षित सिन्हा में देखिए ग्रीन है। मेरे को यहाँ दिख रहा है ना डॉक्टर हर्षित सिन्हा। हाँ, बस एक ही इसी में करना है, इसी में करना है, उसको बंद कर देना है। नहीं आ रहा, स्क्रीन शेयरिंग नहीं हो रहा है। हेलो हाँ अब आया now can you see the presentation है मिला है दिख रहा
Yes, sir.
और ये मैंने एनलार्ज कर दिया नाउ फुल स्क्रीन फुल स्क्रीन ये नीचे जो है ना स्लाइड शो का या लाना स्लाइड शो करना है ना स्लाइड शो ही कर रहा हूं मैं कौन सा थर्ड वाला वर्ड एक मिनट अब आया ओके हेलो
Yes, sir, it's visible.
visible and can you hear me
Yes, sir.
Yes, sir.
एक मिनट अब मेरा यहाँ छोटा हो गया है व्हाट इज द प्रॉब्लम नाउ वेट अ मिनट डिस्कनेक्ट हो गया कैन यू सी नाउ
Yes, sir.
okay so sorry participant there was some technical glitch yeah, though we tried yesterday it went very well for 15 minutes in one shot it started anyhow we are now going to start good morning everybody all the participants and I am very thankful to the RIA to give me once again the platform to share this interesting topic related to social impact assessment under Rehabilitation Resettlement Program for EIA Study. Let me tell you this today presentation has been formed after long experience. The day this law was introduced in 2013. Before that, there were several attempts were made how to introduce this law. So I was tracing the entire event, and today whatever I'm going to present is all the summarized things related to the topic. There is so big vast topic, there are so many laws, so many things that first draft when I prepared it was about 190 slides. Oh man, it is very difficult to present 190 slides, so I cut down to 90 slides, delete out the 100 slides, and I concentrated only on the main slide which will be helpful. So let me check what made this presentation, what made this topic to be presented, because there are two things. When I am in the field, there are two type of people, two type of groups coming. One is affected individuals or family. They know where I used to work. People, I used to work in a village, so most of the people know me. And whenever such incidents happen or the land acquisition come, they call me, sir, please come here, please help us. We don't know anything. So this is the one group, right? How we'll get the justice compensation, right? What are the amenities provided by the government? These are the concern of the affected individuals and the family. And other is related to owners, those who want to buy the land from these affected families, means the farmers or maybe any other group. So they are also confused because there are lot of laws, lot of things are to be done, and how it is to be done, they don't know. And similarly, the professionals like me and many other, they are also confused. Sir, itne sare law hai, how which law is applicable? We are unable to don't know. So what today's presentation is, I just summarize in a sequencing manner how this law was evolved, what was the milestone, how this law came in India, and how law has been changed, what provision has been made, right? So before I shall proceed, I would like to know, I will do a little survey. I will like to know how many are from the infrastructure sector development. Type yes in your chat box. Okay. Rajni, could you help me to see, because I cannot see how many are telling yes?
Yes, sir, they are writing in the chat box.
How many are they? Just give me the number.
So it's currently 2.
2. So
Yes.
they are from the infrastructure sector. Very good. No doubt about this group is very small. It's going to happen, I knew. And let's me at the next. How much you know about the SIA and RIA? First option is don't know. Second is partially. Third is fully. What is the response?
Currently, yes is so partially. There is a response for partially.
Majority are responding to the partially. Yeah, I know.
Yes.
I know it's going to happen. Even today also I can say I don't know the entire law, right? Now the third question is related to how many of you are participating in an R&R education process, not participating partially, fully. How many people are just doing R&R program?
The majority of response is divided between NP and partial.
NP and partial. Okay. So this is a major finding that majority of people are still unaware about the process, and even they don't get an opportunity to participate in R&R project. So the R&R projects in India have gained momently after the intervention of the infrastructure development in India, especially the roads, especially the buildings, especially the bridges, etc. Now, since last 2 to 3 years, many R&R projects are coming up. So sooner or later, these participants will get some opportunity regarding this type of project. So let us go to next slide. Now, let me tell you the last time which I did a presentation, and I approached many of my friends that why don't you join this? They are saying, sir, last time आपने सब बता दिया था, अब क्या बाकी है? So still people don't have the exact understanding what is R&R and how it is been connected to EIA. Let me tell you one thing very clearly, that today's presentation is in context to EIA only. If any infrastructure project comes, it needs EC clearance. And within the EC clearance, there is a terms of reference. First, there is a terms of reference. And within the terms of reference, there is one point: if you are occupying a land, then you should follow these. And these TOR points are being inculcated in by the ministry in the TOR of the respective party. RN plan, I am giving you an example, what kind of TOR points are coming and how these are being interlinked with many of the things. See, RR plan compensation detail project affected area, right? Project affected people, that's the one issue. State and national rehabilitation resettlement policy, which groups is going to be affected, how you are going to make a R&R plan, right? What type of social impact assessment you are going to do. So these are the 3 examples. First one was of mine, other was in industry, the other is related to some canal project. So these points are there. It looks very simple to you, no? Just writing 3 lines, but behind these 3 lines, there are hundreds of laws associated to it, right? So today's presentation, though it is been said that it is social impact assessment and R&R, but in context to EIA, we are the subset of EIA. First EIA comes, then these things come. If there is a land acquisition, then these points are very valid and we should understand each and every aspect of doing it. Let me make it very clear that rehabilitation and resettlement word is a very common word and largely being used in context to the incident happened either by the natural or man-made disaster, and we have to rehabilitate the victims. Now, here I am not going to use this disaster word in my presentation. My main focus will be on the infrastructure development where EC is required and R&R or SIA is the TOR condition, and maybe for the road, dam, canal, flyover, etc., whatever there, and there is a displacement of the population. So here today, I will be concentrating R&R in context to infrastructure development projects where EC is required. Okay, let us move further. What is rehabilitation? Right? In its simple word, rehabilitation is the act of restoring something, any type of restoration to its original state. That's the rehabilitation. Then what is resettlement? Resettlement is something, for instance, for setting or solving by means by agreement by settled in another place. Means you are yes, anyone? I mean that you are. Hello. Am I audible? Hello.
Please, audience, please mute yourself. Let Dr. Sinha only speak because there is a lot of disturbance. Some people have kept their mic on.
It may easy. Okay. Just one person so that I can understand I am audible. So this is the difference between the rehabilitation is a temporary phase where anything happens, you do a rehabilitation and it has been solved. While resettlement is your population has been displaced and settled to a new area. There is a major difference between rehabilitation and resettlement. We will see how it has been practically applied, right? Now, let us come to one more aspect. I have prepared this presentation for two people, proponent and professional, right? What is this proponent? Proponent, one who carry out the infrastructure project, and he wanted to acquire some land, so he became a proponent. So he is more concerned about SIA and RR, entire thing according to this Act, 2013 Act. While the professionals are those people who are involved to do SIA and prepare R&R plans. Who are these professionals? I hope here, I think two people are proponent. They are coming from the infrastructure side, and others may be professional or maybe new to the professional. They want to make a career on it. So this is entire presentation is cornered between proponent and professionals. No other group can come in. Now, what I want to say from this presentation is how this evaluation of historical evaluation of Land Act came in 1894. This is one of my objectives. How such things happened. Huh? Then second is when it came and how it developed in India, the milestone I'm going to explain you. Then third thing is, this is the most important revolutionary thing that happened in 2013, and we have to know this 2013 RFCTLARR Act of 2013 only by chapters. It has 4 schedules, 13 chapters and 147 sections. That makes almost 150 slides. If I go each and every section, and then it's become very difficult. So I have made it concise and make it very informative, so you people, any layman can understand what is there in the Act, right? Then we will go and describe how to conduct social impact assessment. This is, I think, the base of the entire my presentation as well as about this Act. Whenever you want to acquire a land, social impact assessment became utmost necessary. And this is the what you call a beginning. A beginning should be healthy, good. If one thing goes wrong, it will always go wrong. That is a Murphy's law. And the same is applicable in this also, in this Act. If social impact assessment is not done properly, then how it will be affecting to other part of the act, you will see. And I will share one classic example today in this regard. Then we come to understanding the process of SIA, how it should be done and how it should be integrated with R&R program. So SIA would be done by your professionals, while R&R program is something like a proponent. A proponent maybe from the government, maybe from public-private sector, maybe from the private sector. There are three things which are going on. So how he will develop his R&R program and present before the concerned authority for executing the same. So here I have taken care of both the professional as well as the proponent. And then we will discuss one case study. I have a lot of case studies. And it will, in this short period of time, I cannot go each and every. So I have it summarized, but I have taken one case study that will teach you something very good. That as a professional, as an R&R professional, you should not do such mistakes. That will lead to a very, it will multiply. The problems will be multiplied if such things happen. Now, let us take a historical evaluation, right? How this act came. In 1824, our India have a colonial rule, and the British government in 1824 called a Bengal resolution. That law applied to whole Bengal province in relation to obtain the fair valuation land and other immovable property required to construct road, canal, and everything. So they brought it here, and slowly, as they progresses, they want some things to be done to make the process easy, and so they have different type of acts. They are refining that 1824 to 1850. Then they brought a Bombay Act in 1839, then Madras Act in 1852, right? So these acts came slowly. Why these acts came and why this lasted in 1894 Act, Land Acquisition to 1894. This is mainly because the act, owing to the unsatisfactory settlement, incompetency, and corruption was there found in all above the acts, right? So what they thought, why don't we make such a law that gives a fair and compensation to the Land Acquisition Act? So this Land Acquisition Act of 1894 came, and that was developed by the Britishers. What was the reason? I have told you earlier in very short that they need to develop infrastructure. The Britishers were ruling India, and still they want that India should progress. So they have developed this they need to introduce infrastructure development like railroad, canal, and everything they want to develop. Developing public project, governance and administration, and public welfare. They want to integrate all these things with this development project. Essential for economic development. They view, they forethought that India's economy should be stimulated. So they need in order to facilitate the trade, transportation, and communication, these type of projects are very necessary. Secondly, whatever been introduced in 1824, there was no legal clarities. So they want to make a legal clarities, and in the making a specific law and making standardization process, right? Then there was a high, dissatisfaction among the landowners related to compensation. So they want to streamline the compensation process and make it more viable to the landowners. Similarly, this consolidated of several laws they have changed in favor of to the landowners. So this law, these are some reasons where eminent domain or consolidation of the land law was precise and make a real act. It is called 1994 Act. Now, in short, there are nearly almost 28 sections. I make it very pictorial. I'm not going to tell you each and every section, but some important section of 1894, which is something is section 4.1 says the publication of preliminary notification in official gazette and local daily. The moment they need some land, they will publish in local dailies and gazette. It will go through special power of urgency, hearing and objection. There are two options under section 17 and under section 5A. Special power means there is no, they will not listen to anyone. They will have a special power to acquire the land. And another is they will listen. Hearing of the objection and of acquisition, the sole proprietor of the land can act according to section 5A. Now, when it happened that then they prepare in section C declaration of intent to acquire the public purpose. They made a declaration, then comes a collector role, how it should be. They mark out the land area in section 8, section 9, notice to the interested people making a claim on it. They have this all provision, but in colonial rule, who will be exercising section 9, section 11, section 16, section 18? Very few, or almost you can consider none, because we were treated as a what? As a because we were ruled by the Britishers. So we are, some are fear, some don't dare, some don't know technically, they are not technically strong. So these things were missing, though it is in the system. But I haven't read any document related where there's such type of things had happened in 1894 and thereafter. Now, what are the highlights? It's very clear: the purpose of acquisition, notice for hearing, compensation, status of consent not required at that particular time, and provision made, limited provision made for the land acquisition, and resolution was also very limited. These are the, maybe you can say, setback, or you can say drawbacks in the Land Acquisition Act of 1994. Sorry, yeah. Now, what are the limitations associated with the this? The first one is the compensation rate. People were not satisfied the way they have been compensated against their land which they acquired by the government. That was the first objection. The second was absence of rehabilitation resettlement provision. There was no such provision. RR package ही नहीं था उस समय. Whatever they give as a lump sum money to be treated as rehabilitation package. So that was one of the main cause. And third thing, this is most important, the lack of transparency of public participation. At that time, it was like a Hitler rule. No, we have decided we want this, and we will be taking up without concern of the public participation, right? The definition mentioned for this is very vague. Public purpose, though it has been said, but explicitly not been interpreted. It is something like it has been owned by some government, the land. So there is a wide ambiguity about the definition about the public purpose. Then comes no safeguard for vulnerable groups. Kuch nahi, we take your land and you go take a compensation and go away. Nothing to do for the children, nothing to do for the women, nothing to do for the oldies. There was no such provision in that, right? And even though the procedure they adopted is very lengthy, so who will interested in doing lengthy legal procedures? No, because they were the peasant at that time. Hardly people have the money to fight against the government. So the D&D and legal procedures are very lengthy, so people used to avoid it. And there is no uniform compensation. If in one area I paid you 1 lakh rupees at that particular time for that piece of land, in another area the government pays only 50,000. So there is no uniform pattern of compensation practice. There is no criteria what to give, what not to give. These are the limitations. And last but not the least is related with the lack of environmental safeguard. Do hell with the environmental things. We want this land for building a railway track. I give you an example. Go to Dehradun side, and at that time when the railway track were made, all the great trees were cut and the wooden log was placed between the two railway lines. So at that time, trees were kept enormously. उसका कोई हिसाब ही नहीं हो, इतने trees काट रहे थे. So they are least bothered about the environmental safeguard. So these are certain shortcomings of 1894 Land Acquisition Act. Now what happened after that. Now, this is the second part of it, which I'm going to tell you. The second part is very important because how this Land Act was evolved in India after 1894. Let us look at these things. Again, in 1923, India was still under the British Empire, and they have introduced the concept of stating objection. Now they become slowly fair, no? So anybody can take the objection. But princely state are exempted. What? Hyderabad Nizam, Awadh Nizam, Mysore, they were exempted because they have occupied, they have their own kingdom. Princely state have their own kingdom, own land. So for them, it was exempted. Apart from the princely state, which the land is remaining, this concept of acquisition of land to be heard by the competent authority related to objection was adopted. Now, in 1935, right to property explicitly tracing the origin of the right of property. Ye property kiski thi, how to trace. So they are tracing the records. They have introduced this. No, it belongs to you. Give us the proof. Forefathers were the owners. So this was introduced in 1935. See, slowly they are opening. Now, fundamental right, expropriation of the right of property and not right to property. Right to property per se, they propose this principle in the Act. In 1949, it was revised, no person shall be deprived of his life, liberty and property with due process. That was implemented. Matter, if it belongs to you, then everything goes to you. That was something very revolutionary at that particular time, that they thought that no person shall be deprived of his life, liberty or property. No, whatever they have, it will possess to it their name. But what happened in 1963? They have revised the guideline, right? And they had laid out with a detailed procedure how to acquire the land. This was something very good they did, but in 1976, 72 Amendment Act, Article 19. This Article 19 is the crux of entire changing the Land Acquisition Act. Under Article 19, during that particular time, when India was there, the government can take anybody land. There are so many cases. I highlighted the 3 cases. One is Gokalnath case, where entire 500-acre land was seized by the government. Another case was Keshav Anand. He's from Bangalore. Out of 500, 470 acres of land was taken by the government without giving any explanation. So this act says that the government can take away the land at any time using this act. But what happened in Minerva Mill Limited, that is in Mumbai, that something Supreme Court gave the judgment in the favor of Minerva Mill. And there it ends that now government cannot forcefully take any land. There was amendment, death of Article 91 and 44 Amendment Act was there. So many acts. I'm giving you a precise, very in a concise way to make you understand how this concept was evolved. So in the year when I got married, the Ministry of Rural Development initiated Land Act reform in India. This was the first ministry who introduced the Land Act reform. But simultaneously, MORD thought of having land acquisition and national rehabilitation resettlement policy in 2007. This is the most important document. We'll be discussing this document in relation to R&R. So this is the base, right? Are you able to hear me?
Yes, sir.
Yeah,
Yes,
everybody
sir.
is able to hear?
Yes. Yes.
Yeah. Okay. So what I see, now what had happened in 2009, it was produced before the Lok Sabha and SIA was introduced in the bill. 2011, it was produced and then proposed. What certain changes were made for private sector, 80% of affected families, any private land, 80% of affected families should agree. Then only the land acquisition is possible. Under PPP, 70% of the affected funding must agree, then only the land. These were the 4 times the market value in rural area and 2 times the market value in the urban area. Now, it was proposed during 2011. Now it has been changed. Now it is something beyond that, right? Now, at that particular time, Ministry of Coal India, they did a very historical, historical movement, you can say, in relation to R&R. They studied the 2007 R&R policy made by Rehabilitation Council of India, and they have developed a very refined way of R&R, resettlement and rehabilitation policy in context of coal mining project. That is, project affected people. Now they are more, filtering the people. Earlier it was only with the land. Now we are thinking in terms of project affect people. So this was a remarkable, improvement made in the name of resettlement and rehabilitation process. So earlier in 2007, Rehabilitation Council produced R&R policy, and later on, this was revised in 2012 by Ministry of Coal India, and they have come out with such a good document, and they have revised it to in present context. Now, taking all these documents, 2007, 2012, 2011, the bill, they introduced the Bill of Right for Fair Compensatory Transparency in Land Acquisition, Rehabilitation and Resettlement Act in 2013 and September 2003, and it came into effect in came into effect from 1st January 2014. Now the beginning of R&R, that is called Right for Fair and Compensatory Transparency and Land Acquisition, started in India, the real sense, right? They introduced the provision of fair compensation, transparency, rehabilitation, resettlement of the affected family. Greater emphasis were given to social impact, which was missing in 1894, and of land acquisition, and sought strike balance between the development needs and the rights of affected communities. That was this balanced way they have done it. But what happened in 2015? It was again revised, and now the base of any land acquisition, 2 acts are the base. One is 2013 and one is 2015. What revision they have to make? That for the certain projects, we don't need any exemption. They don't need any consent. They have put all these 5 projects were mentioned here, right? Award has been made in 5 years earlier, compensation not been paid for possession of the land. Within 5 years, you have to pay everything. Lot of changes, I will come to that. But these were the major highlights. So whenever you wanted to do any study related to R&R, or you are in the part of R&R, you have to study 4 documents thoroughly. At present, at this point, I'm telling. First is Rehabilitation and Resettlement Policy of 2007, 2012, 2013. This is Right and Fair Compensation 2013 and 2015. These 4 documents is the base of the entire R&R policy of India, right? Let us see what is there. I know how many people will be reading. It is almost around 100 pages. So what I did to make people understand, then I have summarized few points about the R&R policy of 2007. What I did is scope of applicability. R&R needs people displaced by the development project for development project. Involvement of the local communities. I'm putting the headings, and what is being described, I have written below it. Then identification of the project affected family. This is one of the major objectives that was missed out earlier. Entitlement and assistance. What kind of entitlement and assistance would be given? That has been described over here. Then come to formation of R&R committee, which was missing in 1894, but here in the policy of 2007 of R&R, this was a remarkable achievement that they have introduced. Then come social impact assessment. In 1894, there was no social. They said, no. Whenever you want to do or acquire a land, we should have do this social impact assessment. Then what are the alternative source of livelihood? It is very clearly mentioned. And when you are rehabilitating or resettling it, what infrastructure and civic amenities are required at the new places? So they have made it certain good criteria and guidelines. And now what was missing there, it was introduced here, special provisions for vulnerable groups, right? Participation of NGO and civil society. This is one of the interesting things, because the person who is having a land is an illiterate fellow. He doesn't know about his rights. These are the people, civil societies and NGO, they help them to acquire their right of equality, right of justice, right? And then review and monitoring mechanism was introduced in the R&R process. What was highlighted in, certain changes were made, and in R&R policy of 2012. See, you can do the development with minimum disturbance, well-prepared R&R action plan. These are the highlights I'm telling you. And each and every individual should be the part in the planning. The landholders should also be involved in the part of planning. This is something new coming up. Affected person can become a partner of development, leading and improvement in acquisition of land. Means the affected person should be part of planning and development process also. It is not that what the proponent thinks is development. No, they should also be involved. This is one thing, something new, revolutionary things happen. Then consultative and transformative process. Certain process has to be audited very transparently. This was described in the R&R 2012 policy during the time of coal mine. Regain the former standard of living and earning capacity. So when you are transferring or when you are acquiring and resettlement deed, they should have the same standard of living and earning capacity. And this was missing in 2007 CSR activity. So whenever you want to introduce to a new area, the CSR activity should also be integrated to initiate the development process, right? And actual compensation to be paid only after doing household survey. Right now, here comes the SIA rule. Let us look more deeply what is the difference between 2007 and 2012 policy. Why I am giving stress? Because whosoever is going to make a career in R&R or whosoever want to become R&R expert, they must know the base of R&R. So what happened in 2007 is involuntary displacement of the people, while in 2012, policy applies to the project involved land acquisition under the Land Acquisition Act of 1994 or any other law. They took some good points. Earlier it was only involuntary now, but it is become very good that it's become a voluntary. In 2007, policy required residence of 3 years. A person must be residence of 3 years of that particular area, then only he will get a package. But in 2012, it was raised from 3,000 to 5 years. In 2007, choice of annuity or employment. Either you take the lump sum amount or the lump sum amount will be given in installment, or you go for the employment. This was the option given in 2007, which was later turned out changed, that they are entitled to have both annuity, lump sum compensation, as well as employment is mandatory. The government made it mandatory. In 2000, the sustenance allowance was 3,000 for 12 months. While in 2012 policy, it was raised to, it remained the same, but the period was raised to 36 months. एक साल में कौन आदमी survive कर पाएगा with that amount? No, they need a longer period of time. Now I came to know it has turned to 5,000 in some cases where they have intervened of the court. Hello, anybody? Prashant?
Sir, no problem, sir.
Okay. So I have heard, I have read it, that it has raised to 5,000. And now what happened? One-time financial assistance, provision of one-time financial. We will take your land and we will give you 50,000. That has been changed. It has been to 50,000 for the displaced person and 25,000 for the affected family. Now, this is a sub-compensation they are going to give while shifting. But earlier it was only related to the person whom the land is related, not the person who are affected. Here in 2007, 25,000 were given to the affected family. They don't have land, but they live there, so they are affected because they have been shifted. So the government has taken in consideration to them also. Then comes 2000. They put aside some price value, minimum 2005 acres. They gave 1.5 lakh. Now in 2012, 2 acres it raised to 2 lakhs rupees. In policy to provide minimum 50 square meter build-up area, rupees 50,000. This is a rate fixed by the family. In 2000, 150 square meter and 1.5 lakh per family it is to be given based on this rate. So things have been changed, things have been revised. Now this is related to 2012. Now it is 2022, and many things have been changed. But the change has been done as per the court. They went to the court, but this is now the time has changed. Almost 1 decade have passed, so some revision have been made. And if you go case by case, you will see lot of changes have been made on these issues and these point compensation and all that. This is basically, I want to emphasize to the professionals, especially the professional and the proponent, that what is R&R. First try to understand with these two documents, R&R Policy of 2007, R&R Policy of 2012. Then only you can able to understand the 2013 Act. Now, if you open the site, this is the site of Department of Land Resources, and they have listed out Registration Act, Rules and Policy, Title, Rules. We see here 2007 Act was taken, Companies Laws, and it is, when I opened first time, it was so confusing to me because what is rule, what is act? I was unable to classify that particular thing at that particular time. So what I did, I keep on doing internet search, and I came across this. This is Indian Code of Digital Coding System. Well, India have adopted all this coding system adopted about this law. And then they classify what is act, what is rule, what is not. This is their classification. I don't know. When I open this document, Land Acquisition Act of 1805, there it is on the beginning, it is written notification. So I asked one of my lawyer, why this notification? You don't ask question. This is our classification. So please don't ask such type of questions to me. Wow. So this is the way I have summarized it to make you understand the entire law process. We have discussed 1894 in 2013, which we are going to discuss now in very detail. Not very detailed. It is, we go by detail. And somebody's mic is on. Somebody is asking any question.
Sir, I just wanted to ask, what is the basic difference between an act and rule?
Yeah, that's what I'm telling. That is what I'm telling. I am not a lawyer. See, I told you very frankly that this classification, I am not a lawyer. How it has been taken as an act, how it is taken as a first come act, and within that, what I understand, rules become. Several rules are made under the act. What I understood. Still, I don't know the exact what is one differentiation. It is a legal lawyer who will be explaining, and with the help of lawyer, I could do this classification because he told me you go to this site, and that is being done here. When I asked what is, why you, if you open this document, okay, just wait. I don't know why it is not opening. Okay, never mind. If you open this document, at the top of it, it is written notification. If it is a notification, how is been classified as rules? This is something very,
Yes,
very technical.
Confused.
Even I don't know. I am a learner. I am a researcher. Today, I am not an expert. I am a researcher. I have been experienced since last 1 decade or over. So I am able to do all these classifications and all that. If you will sit on the internet and open it, and you will be get confused. So this classification and these all things I have done after taking long pain for doing these things. Okay. So please don't ask these legalities. I will be telling you later on also. So now rules came, notifications came, certain modifications were done in 2013 Act, right? Orders were passed, ordinance were there, small, and I'm going to give you the folder. as a resource material which contains all these things with a different folder having serial numbers, these things. So whatever you want to refer, you should refer with these things, with these number that I made it very easy. I don't know why it is not opening any one. It should open. Yeah. See, this is Ministry of Rural Development, and this is the in relation to R&R procedure. What procedure should be adopted? Request of the land. Everything is government have done a very good job over here. What sort of form you have to sign? Everything is there. So what I did, I just make it synchronize, give a chronicle order, so people should understand what exactly one should do while doing. So once again, I'm telling you, here you forget about 1894. You have to concentrate on 2013, 2015, and before that, you must know National R&R Policy of 2007 and 2012. So before going to any R&R program, first you study these policies, then come to this Act, 2013 Act, and which is largely related to R&R procedure. And 2015, which indulge the procedure of SIA, have introduced the SIA. So these 4 documents are very important so far. Let us move ahead. Now, I have taken 9 parameters, right? 9 parameters to differentiate law. What is law? How the law scope was changed. In 1894, what was the scope? Center and state government for public purpose. In 2013, apart from public and private, Company Act was also there. Society Act was also introduced in 2015. Everything comes. Proprietorship. Prashant, somebody's mic is on. Please request to mute the mic.
Yes, sir.
Of the
Yes, sir.
yeah. So what in 2015, it given a more opportunity to include all those things. So anything anybody wanted to acquire land, he may be at a proprietor, partnership, company, corporation, non-trust, profitable, under 12 Act company, he or that particular entity will be applying is RFCTLARR Act of 2015. Does not cover land acquisition made under the process of Act in 1894. Here it covers land acquisition made under 13 other acts specified in the 4th schedule. This is the change they have made in 2013 in relation to 1894 Act. And whatever they do, they have been passed. And whatever been 13 acts has been introduced, more acts should be could be introduced. That provision they have made through the parliamentary Act doesn't provide rehabilitation resettlement benefit. This 1894. In 2013, more stress was given to this granting compensation R&R. And it also provide establishment, not only the land and compensation, but if you go to a new place, the entire village has to be established there. That provision has been made in 2015. This is, in short, I'm making you to understand. If you go on reading, you will be confused. So I took lot of pain to make you understand the difference between the scope of 3 laws, right? Secondly, now comes what is the consent required. During this time, 1894, the consent was not very much necessary. In 2013, landowners under PPP project, 70% landowners, if they agree, then only land acquisition could be possible. That was added here. In private project, 80% of landowner must agree to shift, then only they can acquire the land, the party. But in 2015, if these 2 things are there, then the process of development would be very slow. And there was a lot of hue and cry, opposition regarding this. So in 2015, government made an assumption of 5 category of projects where consent is not required from the family. These are the 5 categories: national security, defense, protection, rural infrastructure, including electrification, affordable housing, industrial corridor, PPP. If such projects are coming, then it is a government big project. Then I don't think the government made a provision that we don't need a consent, we will take the land. Exemption from SIA. 1894 में SIA नाम की चीज ही नहीं थी. It doesn't exist till 2006. I tell you, I will give today that case which you are going to discuss. The entire gamut falls in this SIA. How this case was distracted because of this SIA. So at that particular time, till 2006, 2008, this SIA was not there. And many things happened during that time. And in 2013, it had become a mandatory in case of, and even exemption for some cases, right? Irrigation project, it is not required. Long, big and irrigation, and they give the condition for that. Government may or may not exempt. I have seen both type of things. In 2000, as we use, they may give exemption. In 5 type of cases project, you are not required for SIA. But in some cases, I have seen SIA has been done. So it depends upon the person or the policymaker who is sitting here to giving the decision at the district or at the state level, whether SIA is there or not. So you should always consult to the authority whether this SIA is applicable to my project or not in this, even in these 5 projects. I know the defense, naturally, rural infrastructure and industrial corridor, they don't need any SIA. Government directly occupies the lands. Then comes your urgency. Urgency is a major clause, no, to conduct the development project. Here, only defense project were given urgency. Here, the some clause of urgency was invoked by the government, giving hearing to the landowner, passing the notice and stating the reason for invoking the clause. The government made a provision that they will first give you notice that urgency, on the basis of urgency, we are acquiring your land. This was there in 2013. And then what happened? There was a revolt among the landowners. They started going to the court. And this how the development process becoming delayed. So again in 2015, it was revived. Now the government can acquire the land claiming about the evidence without giving any notice. This is something very peculiar which they have introduced, so the development process could be continued. Then again there is a clause under chapter 10, and again it was applied to some piece of land, the urgency section. Then compensation should be given in 3 months. Now it is in 1 month. They have changed. Urgency is 3 months. Now they have reduced to 1 month. Earlier it was resettlement package should be given within 6 months. Now it is 3 months. So such and such on urgency basis, those clauses have been changed. Earlier in 1894 till 2008, there is nothing like urgency. It is totally dictatorship. Whatever the government feels, they can take up away. And this is the reason why this 2013 Act was came, putting many variables in it. Now, comparative urgency of transparency. Transparency is such a component where it should be applied to all these things, all these activity in the Act. In 1894, only defense. Primarily, there was some transparency. Just in the rest part of the things, there is no transparency. While in 2013, they introduced that transparency should be there in each and every activity, whether it is a public hearing, social impact assessment, report, delivering report, social impact assessment and group. Everything there should be a transparency, clear, and there should not be any hidden thing. And by surprise, in 2015, some projected are exempted from the transparency. These are the 3 activities which can be, I told you the 5 big projects where the government given some consideration. Where there is no urgency, to me it is also very doubtful. I see if there is no urgency in this case, then what is the use of doing the social impact assessment, right? Or the social impact assessment should be avoided in such type of thing, right? So this is related to the transparency. And now we can move, and this is what we have put up 5 categories I told you. I think these 5 categories are taking advantage of this transparency clause, that here they don't adopt any transparency clause. Okay. make sure, friends, whenever you read all these things, you won't be able to understand. The day I did the classification to make you easy and more understandable. Now what happened? Irrigated multi-crop land. No such provision was there for them. Irrigated multi-crop land cannot be acquired beyond the limit. The government set a limit that till then you can take a multi-crop land, beyond you cannot take the entire piece of multi-crop land. So there was some limit. And in 2015, again, they have a change that SIA is exempted for 5, and they can take this minimum required, keeping a minimum requirement. The government is ensured that the extent of land being acquired is keeping with the minimum, the same condition as applied in 2010. But here, in 5 cases, they can take away the multi-crop land. There is no restriction, right? Return of unutilized land, there was no provision in 1894, and in 2013, they made a provision, return even if of 5 years they are unable to use, you have to return it back. And the same is applied in 2015 also. Even if you come in the 5 categories of that project, if it is unutilized, you have to send it back. Now, very interesting thing happened. Survey of wasteland. There was no provision of survey of wasteland. In 2013 also, there was no survey of wasteland. Can anybody tell in the participant why this survey of wasteland was introduced in 2015? Anybody? Anybody? Why this survey of wasteland? Prashant, are the participants are there? Because
Yes, sir, they are here.
So I think they are feeling bored understanding the. Actually, I am helpless because until and unless you understand these provisions made in the law, you cannot proceed to do R&R activity, SIA activity. My first 3 parts will be related to these laws. The next part will be very interesting. Who are going to involve? What is their role? What are the limitations? You will be, rather than to read, you have to do a concise thing, understand in a very concise manner. I have a limitation of the time. I cannot explain you each and everything. Now, coming back, what do you mean by survey of wasteland? Why this survey of wasteland was introduced? What happened in 2013? What I've read in some cases, they wanted to acquire the land, but they don't have the record where to rehabilitate, where to resettlement to be done. What was missing in the record? Though it was there in the land revenue, but it was not integrated. While later in 2015, this survey of wasteland was integrated within the system. So this helped the concerned authority to make shift upon the barren land or the land which are not used, where the resettlement could be done easily. So this was one of the turning point that had came here. Compensation package. Now, compensation package earlier in 1894 based only on the market-based value. That too, it is shown, it has been marked as a market-based value. But I tell you, the amount of literature I read in that, it is whatever the Britishers or the rulers they decided, that is the final thing. They don't bother even about the market rate. But in 2013, market rate was become a valuable thing for providing compensation, solitium, right? And then 13 Act, Highway Act which was there, compensation of R&R Act, 1st January 2000, that whatever there are market rates, we will take care into consideration the market value. And now in 2015, it had become more specified that 4 times the market value in the case of rural area, twice in case of urban area. Value of asset, it is not only when you are making shifting your land value, not only, but the assets value, movable or immovable property would also be these 3. This is a very remarkable thing. Whatever you got only earlier for the land, now you are getting everything. This is such a good R&R package, which I will show you. And what does the rehabilitation package should contain? It's a good. not only the land, but what other things should be given. That has been revised in 2015, where I'm coming to that also. See, elements of compensation of R&R package, second rule of 2015 Act के अंदर ये दिया है. ये पैकेज डिफाइन किया है. Provision of housing, land to land, offers for developed land, choice of energy and employment, both, दोनों देना है. Subsistence grant, families for 1 year or 3 years. Transportation cost to displace of family. एक जगह से दूसरी जगह जाने के लिए आपको transportation cost देता है. One time cattle shed बनाने के लिए भी देता है. One time grant to artisan, small, everything. Very good package they have made as per the law of 2015. So especially the professional who will be doing SIA, please remember this slide number. Slide number is 30. And you should remember these components. When you are doing the SIA survey, you have to take information related to all these things. Right? Now, what I have showed earlier about the market value, compensation have been changed now. It was now it is 150 solitarium, 120 in urban. Earlier it was 100%. Here there is no mention about that. Applicable to 5 times market value देगा अगर multi crop irrigated land मिल रहा है, ले रही है, या you are purchasing it. Loss of income will be also added now. Earlier there was no such provision. Provision to acquisition of land, stamp duty free कर देंगे, cost of relocation, cost of loss of livelihood, everything is now countable, right? मेरे को एक दिन की दिहाड़ी मेरी 100 रुपए है. So if during that process I involve 6 months, तो 6 months के हिसाब से मेरा कितना बनता है, that is also been given. So this is very good things they have made, added in the compensation, which was not there in 1894, 2013, some provision were made, but in 2015, lot of changes are there, and I am heard, again there is going to be change because of the inflation rate, these rates would be changed. So you have to depend, and you must be very careful while taking the information related to the market. Now, I have come across few cases which says that market value is no longer a yardstick, compulsory yardsticks to measure the compensation package. There are certain cases who oppose the market value because according to them, their ancestor property weight more than the market, because as per the law, the person, revenue officer will come, he will calculate as per the market value. He won't consider the ancestor value of that particular property. So the market value nowadays been challenged in the court, and sometimes 80% of the case got in favor of the landowners, that they have been paid 20 to 30 times more according to the market value. I have so many cases. So today market value becomes a little bit outdated, right? And if the landowner feels no, it is something more, then he won't agree to the agreement related to compensation, and the authority as well as the landowner both will go to the court, and the court decides. Even we have a law for the compensation they will give it, but the market value of that particular land is now being challenged. So I tell you, be very fair in calculating the market value. Take into consideration the landowner's viewpoint also. Mechanism for review and monitoring that was introduced in 2013, in 2015 also. Similarly, distorting that the period before 2013 happened, certain things have been happened, or due to some reason, some court case was there. So that particular thing, compensation was not there or transfer was not made. So in this provision were also made that period will also be considered, and the law is applicable to that period also. Accountability of the government. Now, lot of manipulations are going at the government end, at the proponent end. Now, if you caught up, if anybody pinpoint public litigation against you, then there is the accountability provision of the government apply, as well as the landowners, whosoever, or the proponent who is playing mischief, action would be taken. This is one of the historic things that has been introduced. This is the accountability of the government employee. but there are certain procedures to be followed before taking any action against the government employee. Okay. Now, ये सब क्या कर दिया? What is it? What are you looking? क्या दिख रहा है आप लोगों को? Can anybody answer? प्रशांत, कोई फीडबैक आ रहा है? क्या है ये?
Is it on each state level act and notifications?
Yeah. Good. हमने क्या देखा था previously? Previously we saw 4 acts. What are these 4 acts? 2007, 2012, R&R Policy, 2013 and 2015. ये सेंट्रल लेवल पर आया है नोटिफिकेशन. Now the movement सेंट्रल लेवल पर आया है, all state government has to follow this. Here is the list. No, मैंने पूरा लिस्ट बनाया है. मैंने इसको इंट्रोड्यूस किया था, लेकिन it is not possible me to explain each and every state law क्या चेंज किया. सेंटर क्या सोचता था, स्टेट ने एज पर देयर कन्वीनियंस और एज पर देयर सेटअप, लैंड सेटअप, उनका हिस्टोरिकल लैंड सेटअप है, उसके हिसाब से they had modified the law. Now they have a 5th document, 2 document of R&R, 2013, 2015 of central, and 2015 or 16 state amendment done at 2013 and 2015. यहां पर क्या हुआ, जो हमारा 2013 का लॉ एक्ट आया है, 2015 का जो एक्ट आया है, वो सेंटर है. सेंटर थिंग्स हिम इज ऑल एप्लीकेबल टू द यूनियन टेरिटरी. बट व्हाट अबाउट द स्टेट? द स्टेट कैन चेंज. Here comes the center and state relation. I have seen some laws in small states. They just adopted exactly the same 2013 and 2015. They pass a resolution that wherever the center is, the word center is replaced by the words state government of so and so. That's all. And they adopted the entire thing. While in some states, they made a changes in the provision of acquiring the land, the type of project, right? Andhra, Gujarat, Maharashtra. Go to this link. I will be giving you in my resource material. You will see lot of changes they have made because they see the state ground realities. Center has framed a framework कि ये होना चाहिए, लेकिन now it is state to implement. Now the 5th document comes is the state. So whenever you are doing R&R project, what sort of document you have to refer first to? R&R Policy 2007, 2012, 2013 and 2015. When you understand all 2015 and 2013 document, then you have to see what the state laws say related to RFCTLARR. They have made a modification. What does the center say? What does the state say? I cannot take the entire law over here. Maybe I will give you one example because I am in Gujarat. So I have taken one law. What Gujarat government has done, please excuse me for a while. Before I proceed, how the participants are liking, how it is boring, it is lengthy, it is tedious. Please share your experience on the chat box. Yeah, Prashant, what is the response you are getting?
The response is useful.
Useful. I tell you what there are, if you read, I have read almost 10 years all this law, and then I could summarize to your level so that you people can understand, easily understand, and inculcate something in your professional skills. If you go on reading, I tell you, you will never understand. Since I have been associated from the beginning with a lawyer, so I am able to draw the entire presentation in a very systematic manner. Earlier, this is my 5th presentation since 2013. Earlier, the first 2 presentation which I made, the audience got bored. They literally said, we don't want to understand law. That is the job of lawyer, and I also agreed. That is, why should I explain the law? I must explain the process. And thereafter, I slowly made a justification in my presentation that law is there and what are the process associated to it. How which document has to be referred, not everything. As a professional, at the end, I will give you the list that these many things you have to do for making a career in R&R, for doing the project of R&R. Try to understand that. Please bear with me. You will be feeling sometime bored कि इतने सारे law नहीं know. No, there are only 5 laws which you have to take into consideration while designing SIA studies, while designing R&R program. Come to the point. Come to this. Let us see what is there here. Here you see the state government have changed something with the central. तो सेंट्रल ने जो प्रोविजन दिया था उसको स्टेट ने अडॉप्ट किया है अपने इलाके में. सेंटर ने तो बोल दिया कि इस तरह के 5 प्रोजेक्ट्स आएंगे एंड you don't need any transparency, you don't need any permission and all that. But it is applicable to center only, center projects. But when that center projects come to the state and a state doesn't have that provision, then it cannot be executed. It can be challenged in the court. So most of the government had made certain changes in the provision of acquiring the land, in the provision of getting the project. So these are certain changes made by the government of Gujarat in relation to the 2013 and 2015 Act. How it can be feasibly, practically implemented in the state. So when I request you, after reading 2013 and 2015 Act of R&R, please explore the state document of R&R, of this Act 2013. What changes have been made? Earlier I've shown you the entire list of each state. Understand? So now there are 5 documents, 2 R&R policy, 13, 15, and now comes a state level. You have to understand all laws in context to state level. The state government says this center provision is not applicable to our state because our state setting is this, so they made a change. When you are working in the state, you should remember the central rule but follow the state rule. This is what I want. This is the entire crux. Sir, Sinha sir तो बोले थे 2013 और 2015 ही follow करने का. That is wrong. You are judging me wrong. I am telling you the truth. Your base now is become whenever you do. Even in the compensation. Compensation में क्या होगा कि whichever is the highest. State का अगर clause कह रहा है कि इतना ज्यादा compensation मिलेगा तो state को follow करेंगे. The victims, the land, जिनका लैंड जा रहा है ना, they don't follow center policy. They say no, state में जो बोल रहा है उसमें उनको ज्यादा पैसा मिल रहा है. I will follow that. So try to understand there is a change now. Apart from वो जो आपने 4 डॉक्यूमेंट पढ़े हैं वो आपके नॉलेज के लिए है ना. You have to follow exactly the state document. Remember, point to be remember. Apart from 4, there's a 5th document come, state document of R&R. State government ने क्या क्या change किए in context to the central 2013-2015. Maybe some, maybe the same, but what change they have made, you should know before executing any SIA or R&R. Okay, are you clear? Nobody is responding. I don't know. People are.
There is a response in the chat of yes.
Okay. Okay. See.
Sir.
So, yeah. Tell me. Anything? Okay. We are proceeding further. So now there is a 5th document, that is the state government. And this is the most important document. Yeah.
Sir, there are 2 questions in the chat also regarding the laws.
Yeah.
So one is from Santosh Pant, which asks, does a state government have the power to amend the act introduced by the central government?
Yes, very much. And they have done it. Just see, let me complete the first one.
Okay.
ये इतनी सारी गवर्नमेंट है. There are 31 states ने ये documents हैं, link है. They have changed. They have to do it. small state like
So in most of the states, they have made rules under these acts, sir.
they follow the center. The base was the center only. Yeah, the base was the center only. Even in
making rules for states, sir.
Your voice is not clear, sir. Could it be more?
The provision of making rules under this Act of 2013. But I just wanted to ask whether the government has power to amend the act.
Government has power. The central has given a provision that this act of 2013 and 15 should be implemented in your state as per your convenience, as per the state setting, as per the existing law of the state. The center thinks universally, right? So they gave the power. So these are the documents, sir. This is the list where they have made the changes. Right? Assam, Andhra, Chandigarh. Andhra का बहुत बढ़िया है. छत्तीसगढ़ का अच्छा है. Goa, Gujarat, Haryana, Himachal, Jammu Kashmir, Jharkhand, Karnataka. Everybody has changed. मध्य प्रदेश, very good document. महाराष्ट्र का सबसे बढ़िया है. इनकी RR पॉलिसी भी अलग है. गुजरात की भी RR पॉलिसी है अलग. I mean, I am coming to that also. So वो प्रोविजन है, गवर्नमेंट ने दिया, इसलिए इतने मेरे चेंजेस आए हैं और ये मैंने लिंक्स दे रखे हैं. आई विल बी गिविंग इन माय रिसोर्स मटेरियल. आप जिस स्टेट में हो, ओपन योर स्टेट एंड दे विल से. नागालैंड का खोलोगे, दे हैव गिवन वन. मिजोरम का खोलोगे, दे हैव गिवन वन लाइन जजमेंट पास कर दिया कि जो सेंटर में है वही हम स्टेट में अप्लाई करेंगे. जहां जहां सेंटर वर्ड इस्तेमाल किया वहां वो लोग ने स्टेट डाल दिया. एक रेजोल्यूशन पास कर देने दो ओवर, बिकॉज दे आर एग्जैक्टली रेप्लिकेटिंग द सेम. While in some state, Andhra, Maharashtra, Gujarat, then this Jharkhand, Pondicherry, West Bengal, Uttar Pradesh, सब ने change किया है. थोड़ा बहुत changes है. Right? It is not Harshit Sinha. This is what I have did the research and came out with this. Right? So this is example of Gujarat, what amendments they have done. I will request you, whatever state you belong, please click the list. And try. अगर आपको नहीं मिलता है डॉक्यूमेंट, प्लीज कॉल मी, आई विल सेंड यू द डॉक्यूमेंट. हर स्टेट का अलग है. नाउ कम वन थिंग अगेन. क्या क्या ढूंढ के लाते हैं सर, आप सब सोच रहे होंगे, राइट? नाउ इन सेक्टर डेवलपमेंट प्रोजेक्ट, विच सेक्टर यू बिलोंग? यू बिलोंग टू माइनिंग, यू बिलोंग टू ब्रिजेस, डैम, कैनाल. उसके अंदर के भी कई रूल्स हैं R&R के. मेट्रो के लिए अलग है, हाईवे के लिए अलग है, पेट्रोलियम के लिए अलग है. सी आई प्रिपेयर द लिस्ट. ये लिस्ट शेड्यूल 4 में है 2013 के अंदर, एंटायर लिस्ट. मैंने वो लिस्ट प्रिपेयर करी, वो डॉक्यूमेंट्स ढूंढे, उनका लिंक प्रिपेयर किया. एंड फॉर यू पीपल, इफ यू आर इन्वॉल्व इन ट्रैमवे एक्ट या ट्रैमवे बनाना चाहते हो, या यू आर नेशनल हाईवे एक्ट, वो क्या है, प्रोविजन 1956 में क्या था, यू मस्ट नो दैट ऑल्सो. उसके अंदर R&R का प्रोविजन क्या था, कंपनसेशन का प्रोविजन क्या था. दैट्स व्हाई आई एम टेलिंग यू ना, अर्लियर व्हेन आई प्रिपेयर्ड द फर्स्ट थिंग, इट वेंट 200, above 200. So I discarded the state and sectorial law. सेक्टर के लॉ जितने थे मैंने लिस्ट आउट करे, मैं उनको डिस्कस नहीं करूंगा, अदरवाइज इट विल बिकम टू लॉन्ग एंड यू पीपल विल गेट बोर. तो नाउ कितने डॉक्यूमेंट हो गए? 2 R&R के, 2007, 2012. Then comes 2013, 2015 of center. Then comes state law, and now comes the sector law. So 6 documents. Anybody who is going to do R&R project, either the proponent or the professional, to explore their role, the provision made in it, should go through hierarchically the document this way. Then only you are able to. Yes. Any question?
हेलो सर, मैं विपिन मकवाना गुजरात से बोलता हूँ.
हाँ बोलिए बोलिए. गुजरात से.
सर, उसमें लैंड एक्विजिशन में शेड्यूल ट्राइब में वो पेसा एक्ट, पंचायत एक्सटेंशन इन शेड्यूल एरिया लागू होता है, तो उसके लिए कोई अलग से प्रावधान है या?
नहीं, मैं आपको बताता हूँ. कमिंग, आप समय से ज्यादा आ गए. वो सोशल इम्पैक्ट असेसमेंट करेंगे ना, तब वो हम पंचायत का भी रोल बताएंगे, क्या करेंगे. राइट? दैट इज अ डिफरेंट थिंग. अभी वो डिफरेंट, अब एग्जीक्यूशन का पार्ट नहीं कर रहे, अभी हम लॉ की बात कर रहे हैं। जो आप बहुत बढ़िया पॉइंट होगा, आई एम कमिंग टू दैट ओनली, आई विल बी एक्सप्लेनिंग आफ्टर इन द लंच सेशन। SIA जब हम शुरू करेंगे, पंचायत का रोल क्या है, राइट? ओके, सो अभी हमारे पास 6 डॉक्यूमेंट हो गए। पहला 2 R&R का 2007 2012, देन सेंट्रल एक्ट 2013 एंड 2015, उसके बाद स्टेट एक्ट 2016, ज्यादा लोगों ने 2015-16 में मॉडिफाई कर लिया। सम इवन हैव डन इन 2000, मे बी 2015 में ज्यादा लोगों ने मॉडिफाई किया, 16 में सब लोगों ने करा। तो 2016 का स्टेट एक्ट एंड रिलेटेड एक्ट ऑफ दैट पर्टिकुलर सेक्टर, द प्रोजेक्ट विच यू आर टेकिंग अप, वो किस सेक्टर को बिलोंग करता है, उस सेक्टर का आपको लेना बहुत जरूरी है। क्योंकि क्या होता है, व्हेन वी प्रोड्यूस RRN प्लान और SIA रिपोर्ट, देन सामने वाला जो पार्टी है, ही इज मच स्मार्ट, वो ये कानून ढूंढ के लाएगा कि उसमें ये लिखा, वो आपने कंसीडर ही नहीं किया। टेक एन एग्जांपल ऑफ, कहीं नहीं, आई विल टेक वन एग्जांपल। कोल वॉज तो ठीक है, आई विल टेक वन ऑफ द एग्जांपल ऑफ दिस एनक्रोचमेंट ऑफ ट्राइबल लैंड, हाउ इट इज अफेक्टिंग R&R। पूरा एक गवर्नमेंट ने एक वो निकाला है, इफ इट इज अ ट्राइबल देन इट्स अ ग्रेट हेडेक, एंड if you are in the region of tribal, you have to follow these law in the matter of compensation, in the matter of doing SIA, in the matter of preparing R&R compensation, R&R relief program. एक पर्टिकुलर ग्रुप के लिए भी लॉ है। Try to understand this. I am not telling that कि ये मैं अपने ओर से नहीं डाल रहा हूँ यार, I am not making a thing complicated, but I am warning you to understand this complication. आप अपने सेक्टर में तो आ गए, आप सेक्टर के अंदर ग्रुप्स भी हैं, विद इन द ग्रुप्स एक ट्राइबल ग्रुप आता है, एक शेड्यूल्ड ट्राइब्स, एक शेड्यूल्ड कास्ट, एक अदर बैकवर्ड क्लास और एक इंडिजिनस ग्रुप, सब कुछ है अंदर, है ना, सबके लिए लॉ है। एक हमारा देखिए गवर्नमेंट लॉ है।
Doctor,
Yeah.
some people are not able to follow Hindi.
Okay,
let's
I'm
try
telling you.
to more English.
Sorry. Okay, I will try to see. This is a law. That is land governance under the 5th schedule for tribal. Now, if you want to vacate a tribal village, these laws are applicable in R&R. So it is not only 2013 and 2015 or state law or your sector law. It is particular group laws also there. So please remember what I mean to say, that now 4 to 5 documents before framing any R&R study, you have to go through the laws. These are the 5. One is 2 R&R law, central law 2, 1 state law, 1 sector law, and then 1 particular group law. किस ग्रुप को बिलोंग करते हैं, कौन से ग्रुप को, कोल माइनिंग एरिया, कोल वर्कर्स के लिए अलग रूल्स एंड पॉलिसीज है। Got the point? So now at least in your mind it is become very clear to introduce, to make a career or to start a project or to do consultancy in R&R, you have to take all these steps, especially these 6 documents. You have to first review it in context to your project. Got it? So it is not my invention or something new. It is already being there and people used to forget. If you see this transportation, almost each and every transportation, each and every state has guidelines for land acquisition under national highway. Thanks to Ministry of Road and Transportation. Okay, they have done a marvelous job. सब जगह इंफ्रास्ट्रक्चर बढ़ रहा है, तो एवरी स्टेट आप सर्च कर लो, ईच एंड एवरी स्टेट, गुजरात महाराष्ट्र का ऑलरेडी है, आई हैव ऑलरेडी इंट्रोड्यूस इट, आपको मिल जाएगा. एंड इफ यू वांट टू डू, यूज दिस link and you will get for each and every state. So be sure the sector, the group, and the type of project you are dealing in R&R. This is what I am telling you. These are the laws, 2007, 2012, then Center Act 2013, 2015, then State Act, sector law, law associated to population and group. Got it? So this is the crux of presentation so far, whatever I have made part 1, part 2. It is a crux of all the things. Do not read so many, there are so many laws, but you have to concentrate. If you want to make a career, if you want to execute R&R project, you have to know all these 4, 5 or to 6 document before it execution. Okay. Now we will understand very deeply 2013. It is consisting of 33 pages. And if I made a slide of 33 pages of all the content, it will come beyond 100. So challenging part for me was to explain the entire RC law of 2013 in just 10 to 13 slides and make you understand, or otherwise you have to read it. But mostly people don't read it. How will read? Such and such law is, and they don't know which law is applicable to me. Right? So I try to make it more precise and make you understand. At least if you understand that only, you go to that particular law, open that law, read, because it is applicable to me. Not all law is applicable to professionals, but for proponent, the law applicable to the professional and the law applicable to the proponent will be different. Proponent will be having more laws, while the professional will be having very restricted role in doing the SIA. Let me take it, before I proceed this, I am an experienced SIA professional under this and subsequent changes made, which I trace it of my interest, and I do it. The summary provide brief is a brief overview of key section, is not a substitute of legal advice. For legal advice, you should always consult a lawyer. I tell you, in the entire gamut of this R&R project, lawyer is the main person because he is the authorized person to deal the law. If people like me and you go and you start explaining the law, you will be thrown out. We don't know legalities, no? Here, though the law and act was given in the act, but you are not the person to execute that. It is the authorities and their legal cell and the lawyer associated to the legal cell will be authorized to do. We are going to do certain phase of it. And this may vary as per the project or acquisition scale, small or big land acquisition, or the type of the act keep on revising. So I cannot have a trace on each and everything. There are 4 to 5 websites of our law, Indian laws, by parliament, by lawyers association, by judge association, and see their judgment. I tell you one experience of me. I was in the village and there was a conflict between the landowner and the acquirer, the proponent. The landowner lawyer was telling the same law in a different way. The proponent lawyer using the same law and interpreting in a different way. Our laws are such. So they say, I am correct, I am correct. But when it went to the court, and the court, the judgment gave, it was something very different. Neither of them. The judge gave the judgment in very different meaning, keeping the same law. So this is a legal battle. Do not fall in that legal battle. I am giving you a brief. Please don't misunderstand me. I may be wrong while explaining. Maybe मेरे से गलती हो सकती है. I can say I do mistake. But please take it as only a reference point. Or otherwise you have to study the law with the help of lawyer. This is what I mean to say. Now, this act, it has 13 chapters, 114 sections, and 4 schedules. Such a big thing. And when I started, I made these slides, I think, 3 months back. And it took almost 1 month to arrive to these 13 slides. What should I present to my audience so they remain intact? They have an interest. If I will describe all these sections, everything I know, I'm definite people will leave immediately. I don't know what he is doing. I'm playing the role of a lawyer. No. I'm a researcher. I'm a professional. So how I should do? That is a challenging thing. And let us see. So these are the things. 13. Today I'm going to explain the entire 2013 Act in relation to this 13 chapter. So only 13 slides are there. Within the 13 slides, 4 schedules and 147, what are the sections are there? 114 sections will be covered. Each slide will covering one chapter, and I'll be giving you highlights of it, of the section, main point which you should remember. Okay. Now chapter 1 is a preliminary. It relates the short title, extent, commencement, application, definition, act. What this section applied? Both short title, definition, सब कुछ explain किया. Family किसे कहते हैं, transparency किसे कहते हैं, right? Urgency किसे कहते हैं, everything is described here. The first 3 sections describe this and what are the process, framing R&R program, designing project strategy, decision making, who are the decision makers, and who are the professional involved. Whenever you start, now I'm looking from the professional point of view. A proponent and a professional, both are sitting together. And who will be doing what? Top level management of the proponent will be studying these 3 things. Because their legal cell will be there. Concerned land lawyer, government, PPP, whosoever is there, proponent, they will first study what is the provision, what definitions, what does the law means in relation to family transparency. They will understand this. Okay? Interpreting the entire thing. This is again now difference of opinion. The proponent will say, no, mujhe to something, I think this law says something. The lawyer will say, no, this is something else. While the government with whom we are going to work, they will say something else. So there is always a conflict, difference of opinion of that particular law. Now, when we do this thing, whatever in my 15 years of career, the priority setting for doing R&R project and budget provision. These are the 2 main limitations we come across with the proponent. Whether I should go or not, whether it is my priority. Suppose with that acquisition of land, if I establish a dam over there, I mean in case of government, in case of private property, if I establish a factory over there, so how much earning? So this is the priority setting. So whenever I used to discuss, I come across these 2 points. That is a limit, that becomes a limitation. Some say, oh, we will just delay now for 6 months. Some say, no, I don't have money. Some say, I have everything I want just now. So this is something limitations that is in relation to this chapter 1, right? So what I am not going to describe everything. My main concentration is to let you know the process and activity involved in that particular section. If you want to know the section, go and read that particular section. And who are the professionals involved? What are the challenges encountered while doing that particular thing? And what are the limitations? I am concerned with these 4 sections. So you can read it from the thing. Now the next is determination of social impact assessment in public propose. Now section 4 to 9 describe the entire process of doing the social impact assessment, right? This is 3 to 4 sections are there. What is the first process or activity involved is the formation of SIA committee, formation of SIA team, processing of data SIA, processing of and conducting public hearing, submission of assessment, SIA committee, role of SIA committee, about the consent requirement, roles and responsibility for executing the SIA impact assessment plan. Who are the professionals involved? SIA committee members, representative of local bodies, professionals, those who are doing, people like me who already do the SIA survey, social sciences, gender space, हमारी team होती है, entire team will be going, member of SIA, authority consent, legal cells, everybody will be there. You have to take, there is no team, and in each and every aspect, because the section and the law say something else, before framing any questionnaire or any data collection tool, you have to design, you have to select, you have to consult the proponent. These are the things as per the law we are doing, then you consult the lawyer. So it is group work. These are the things to be. What happened actually? What is going on? Lack of awareness, understanding among SIA and the stakeholders. Yeah, the teamwork is missing. One will say, some professional will say something else, other will say something else. You have to come to a common point. Some people even don't know what is SIA. And Second thing is loosely SIA bond. People will see the tender. SIA, you have to do in such and such rate. I'm coming to all the in details in SIA. Can a person in an area where 5 to 6 villages has to be rehabilitated, each village is consisted of 80 families or maybe 100 families, and you have to prepare an SIA database. How loosely they are doing the survey. This is one of the major challenge. Then capacity. What is the limits in the capacity of doing quality SIA? I know this how SIA has been done, just filling the form without understanding the consequences of it. At the end, we are going to discuss a case study, and that is the consequences of SIA only. The importance of SIA is very strong. Especially, please remember, SIA section 4 to 9, you have to go very thoroughly before doing anything. Make a consent committee internal with the proponent. Come to a common point that is agreeable to the landowners to whom you are going to survey, the proponent for whom you are going to do, and the authorities who are going to involve you, helping you in getting that particular land. So all the three things are there. This is the base of R&R. If one thing goes wrong, it will always go wrong, Murphy's law say. So here in R&R program, if SIA is not done very properly, everything, every jagah, every time, in every step, there is a law contradicting to that, and you will be challenged. Got the point of the chapter 2? So the professionals, right? Even the proponent. Chapter 2 is important. So you are restricted professionals to conduct the SIA. How to conduct, we will come to that also.
So just one question, that who is the one who has the responsibility to prepare this SIA committee?
Yeah, very good question. Very good question. Now what happens? If it is a government project, the authority decides the SIA committee. If it is a private project, then the proponent decided to whom he should be involved. There are certain guidelines to that, who are the members should be involved. But it depends upon the nature of the project. If it is government, it is a public, private PPP, or it is totally private, or it is a trust, or it is a non-profit making company, or it is a proprietor's company. So depending upon the nature of the entity, the committee formation is there, and there is a norms who should be involved in the SIA committee. Right? I'm coming to that also. Very good question. Now, special provision of safeguard food security. This is one of the major things in the process of development, that you keep on buying the land, and the day will come that no land will be remain for the agriculture purpose. So there was some provision made in section 10 that to certain limit only the fertile area will be taken up. I've given you, and other area is reserved for the food, for the production, agriculture production. So there is a limit to that you cannot occupy to certain limit. You cannot occupy the entire fertile area. You will be given 20% or 30% of that. That's 70%. So this law was very much needed. Or otherwise, what will happen? It will happen what? One day, the production of food will be deteriorated and cement buildings will be there. What will population will eat? So this law was very much intact. It covers in section 10. It gives you a brief description about that, or a detailed description. I have written here brief description. And who are these SIA committee members? Because they want land. So they should understand this law specifically. And survey team. Whenever they go into the field, they must check, cross-check, whether it is a fertile land where we are going to occupy. Okay. Oh, challenges are many. Manipulations have been done at various levels. This is my experience. This major challenges and limitation is not written in any document. This is basically my experience which I have faced. Limitations क्या? Virtue, vested interest है. By virtue कभी हो जाता है. Interest, ignoring resistance. There is a resistance, but ignore कर देते हैं. Development priority is high. मुझे ये चाहिए land पूरा. I want this land, the entire land, fertile land. A lot of politics are going on in that. So make sure that there is a special provision in this regard in the Act. Next come notification of acquisition. Section 11 to 30 gave you various types of notification. अगर लैंड खरीदना है तो एक नोटिफिकेशन देना, we have to advertise either as a gazette or publish in a newspaper, right? Who are the competent authority authorized to make the purchase land or to mediate the purchase. This everything is written here. Who is the person who will say now you are good for TOR, for SIA, everything, the roles and responsibilities are given. And here the collector office, the collector of that particular area or districts play a major role, because as per the law, if you see the previous one, in 2015, it was collector made responsible to do each and everything in relation to land acquisition. So notifications, whatever in relation to advertisement, in relation to acquisition, in relation to SIA, everything is done by a collector and his team. Major challenges, what are the major challenges? We do take a lot of things, procedural things, but we forget many things in relation to livelihood. Land is been purchased. How much livelihood is? Most of the time what I see, the justification for the livelihood made is very loosely bounded. This is my observation. In your area, it could be other thing. And difference of opinion between the collector and R&R committee. The committee will say something else, the collector will say something else, and there is a clash over one issue, any issue. So these are the major challenges to implement. And what happened, what is the major limitations is we are dependent totally on the collector willpower. Whatever he say is true, is correct, you have to follow that until and unless you challenge them in the court. Quite often I have seen in such type of cases, many people have gone against the collector viewpoint into the court and they have won. So these are the limitations and sometimes market-based value when we develop a compensation. So here the Schedule 1 is involved. Schedule 1, you see, compensation for landowners. It defines the criteria. What are the things? कैसे करना है? So our collector साहब is restricted to this law. But now market value doesn't have the significance. Many cases I have seen. He has a limitation. No? He will not go beyond the law. Whatever law is written in 2015 or 2013, I will go, provisions are made, I will go according to that. Even his subordinate team, revenue department will go accordingly. But most of the time, especially in the areas situated near the urban area, the cost of land, there is a difference of opinion about the owner and the evaluator. Owner says my cost of land is high, in future is going to be high. Second point is, you don't know the significance of this land. This land is owned by my ancestor property. It has some weightage. It has some weightage, significance weightage. So it doesn't accurately calculated according to market. This is beyond the market value. So these are the conflicting points in the nature of notifications fixing the price of the land. Rehabilitation and resettlement award. This is one of the interesting things. Just a minute. Rehabilitation and resettlement award. Here the section 32 to 42 gives what are the provisions should be made in the compensation package of R&R. Right? Substance, allowance, compensation, entitlement, employment, housing, then area development, correction measures are also there. Process involved, mode of payment should be made in bank only. development of benefit plan, compensation solitum. This has been, now who are these people who are developing this benefit plan and how it has been developed? These are developed based on your SIA report, whatever you have. After lunch, I am going to discuss all those things, interesting things. So it is not authorized by the proponent. Proponent can do. If a proponent is government, he knows he have to follow that. But if a proponent is a private sector, if a proponent is a trust, he will develop his own package and put forward to the government for his execution. The government may not agree. It seems it's very low. So there are certain rules and regulations. Refer slide 30, which I've already shown. Schedule 2 is applied there. What does this say? Element of resettlement. What are the provision of housing? Land for land. Offer to develop land. Choice of amenity of employment. Subsistence granted. Displaced family. Transportation costs. Cattle shed. Petty shop. Right? One-time grant to small artisan. These are the provision made in the government records. And I tell you, here is the main gamut played by the private party. Even the PPR also play, but the government project, they strictly follow this, that's such and so. But a lot of manipulation is going on in. And here plays the collector a major role. Revenue Department, Relief Commissioner, they know the rules. And if a person come with a low plan, giving a low compensation, they will challenge that. They will reject it and their team will prepare accordingly. So this is something very important role. Now, display minimum public amenities. So we are talking about this is all of individual family affected. A person or family living in a village. So in a village, what infrastructure should be made under this rehabilitation package? List of there. The entire list is there. And we are coming to that also in our SIA exercise, SIA survey, how to do SIA survey. Then I will explain you in detail everything. So these two schedules you must refer, especially the professionals who are going to engage in SIA survey. They must know. Proponent should know everything. But this particular thing, professionals who are going to do SIA survey must know. Who are the team specialized here in doing so, in calculating these things? Is the collector and his office, a specialized ministry. If it is an area of scheduled tribe, then scheduled tribe ministry will be looking after scheduled caste. And depending upon the owner, right? It's come from government or PPP or private or trust, he will also there. He will put his idea, they will check and then they will pass the bill. Okay, this is okay, this compensation is okay. The major challenge which I have found is on two things. One is you don't know the time. Kab complete, though it is mentioned within 2 or 3 years you have to complete it, but not possible. Why it is not possible? Because the after effect comes, that is the political interference, right? And there is one most serious problem which most of the proponent, most of the professionals, and even the government officials don't understand. What is that problem? Sorry. What is that problem? Let us see this problem. It is a very practical problem. What are you looking? A figure, a submerged area, which has gone, an area which has gone to the development project. Rehabilitated area, temporary shifting.
Excuse me, sir.
Yeah.
Sir, the file you are showing is not being shared in the screen.
This particular.
Yes, sir. Yes, sir. The PDF which you are showing is not visible in the screen share.
So far, whatever PDF I have shown is not visible.
No, sir.
Earlier PDF. That's a major problem. Pardon? Okay, let us stop 15 minutes before, because I will resolve this problem. because these are certain schedule which you should there. It is there. It will be coming to as a resource material, but this problem is very acute. And wait a minute. Now you're able to see the small slides?
Yes, sir.
Yeah?
Yes, sir.
Yes.
Yeah.
Wait a minute. Let me complete this slide.
Your link is not working, sir.
I think the link has gone up. I don't know. Till morning, the slideshow, if we work from the slideshow, it is going on, but I don't know about this reading review. It doesn't connect. So now can you see? Hello? Can you see this slide now?
No, sir. It's currently in the multiple slides mode.
Okay, wait a minute. Can you see now?
No, sir.
Huh?
No, sir.
No,
No,
sir.
it's all multiple slides.
Now, are you able to see now? Wait a minute.
There are 24 slides right now on the screen.
Okay,
sir,
wait a
instead of-
minute. Now can you see this slide?
Yes, sir.
Yes, sir.
Very
Somehow
good.
it is not the presentation mode. That's why these links are not working.
Yeah, these links are not working. Let me work out on after lunch, see what had happened. Otherwise, yesterday it was working. I don't know what had happened today. Now see, this is a major practical problem. After this, I will stop. We will have a lunch break, right? Now, this is a major problem whenever you do a rehabilitation process. So this is the brown area. Submerged area means lost area. It may be 16 villages or 5 acres land or 10 acres or 100-acre lands, whatsoever may be. Now, the owner, maybe a government, maybe a private public partner, maybe a private sector, he wants that the thing should be completed within 3 years. What does it mean? It means that the new area where they have to be rehabilitated, permanent settlement, that should be developed within the 3 years. And currently they are staying at these places which they want to vacate it because they want to start the economic activity immediately. So then comes a rehabilitate. That is a temporary place. They will select a place in an area with the permission of the local authorities and they will make shift over there, make a temporary tin sheds. This is one way. Or if it is not in urgency, then the people are living here, no doubt. The commercial activity will start only after 3 years. But within the 3 years, they will occupy, do all the necessary arrangement or settlement to acquire new land with the district or the state or the concerned authority and start developing it. Now you think in terms of cost. The major, I tell you, the conflicting point is among the proponent, whether it is the government, private sector, public private sector, while shifting one place and establishing a temporary shelter and then establishing a full village. What is the cost involved? This has been forgotten in the planning by the proponent. Then it is, if it is a government, by force you go here, we will develop you. So they will live in a temporary huts and by the time it will be developed. Though there is a provision, until and unless R&R activity is not there, no land use change could be made here. There is a law. And this is the conflicting point. This is a major conflicting point. Practically, I tell you, I faced. Okay. So whenever, wait a minute. Okay, we are here. Okay. Are you able to see? Now, can you able to see the slide mode now?
No, sir.
No, sir.
Oh, I don't know. Okay, we'll go to reading mode only now.
नहीं
So,
अभी हाँ
we are in the reading mode, sir. Slide down. I don't know why this slide mode is not working.
नहीं but
So
it's
see,
okay, it's in presentation mode now.
now, so you got the point. Rehabilitation and resettlement award में major problem यहाँ आता है, and this is the reason why majority of R&R awarded plan get halted. Because the proponent cannot decide. This decision should be made in the planning purpose only. We will first allot them in a temporary place, or we will take 1.5 years, we will wait, we will develop the new area, and then we will allow them to shift there. And that cost is not involved. Neither from the government side, nor the law say. Law also doesn't say about that cost. Go thoroughly this law. Go this section. It doesn't say about these things, the problem which has happened. Okay, and this is a major limitation, delay. Provision of budget at that particular time you feel, oh, we don't have this provision of temporary shelter. And this is one of the important aspect in planning of R&R. The first slide you see now, define the definition, the groups and all that. In that particular thing, when you chalk out your plan, you should first decide whether we should go for the temporary. Yes, anyone? Yeah. Okay, so it is almost now 1, only 5 minutes or 5 to 10 minutes are remaining. Would you allow me to take a break? Because there is a problem in the presentation that we have to sort out. And
well, I was wondering, it's already 2 hours, Doc. You had been talking. Let's take a break, and probably let's meet at after lunch.
Yeah, 2 o'clock most probably.
We meet at 2 o'clock, friends.
Almost we have covered 50 slides. We have covered 50 slides, and within 2 hours, 40 slides. That will be a very interesting also. Okay.
Yeah, there are another 45 slides left. 2 hours is good enough.
2 or 2.5 hours. But I want to know just
early, Doc? Instead of 2
maybe
o'clock.
1:45 is okay.
Yeah, let's meet at 1:45, please.
Okay.
So
okay,
friends,
we will meet at 1:45. Thanks.
Now there are some chats which are there, Doc.
Yeah.
1:40. Please share all slides. We will share the slides. We have already mentioned that.
Yeah, I will give you all resource material. We will give you the slide in PDF form. All links will be given to you, all schedules, all related things. By Monday, you will get everything. Because Sunday, I will compile the entire thing and send it to the Rajni, and Rajni will be sending to.
Doc, generally what we do is we send this material along with the certificate.
Okay.
So it might take 1 or 2 days more. Once we have all the certificates prepared, and then along with the certificate we send the material also. Okay.
But I just want to know.
Permission of all the participants, we take a break for lunch. We meet here again at 1:45.
Okay. Thank you, sir.
Thank you, Doc. Thank you.